Good morning, Ms. Silolo.
Good morning, Chair. Good morning, Commissioners.
Good morning, Mr. Magagula.
Morning, Commissioner.
Thank you.
Thank you, Chair. Morning, Mr. Magagula.
Morning.
Please find your statement file again.
I have it.
When we parted yesterday, we had gone as far as your page 8. And at page 8, you had dealt with the case of Boxbed Cast 262/03/2023, the blue lights matter. And that's where we stopped yesterday. So we are going to pick it up from there. Thereafter, you deal with the next case, correct?
Yes.
You call that the Fontaine Cast 86.
Ms. Silo, maybe before you do that,
Yes,
can I just ask a question relating to the first one?
Absolutely.
That was dealt with. And this is just a general question. In this blue lights case, I know you didn't deal with it, but we got the report. We've seen the report of the IPID to the city. And one of the areas of concern with previous witnesses for us, the commissioners, was that the IPID seems to have been concerned just about the amount that was spent to register the city's money, 2,000 odds rand, that seemed to have been the IPID's focus. And that suggested, as if that suggested that that's what you thought is disciplinable and nothing more. And I say this mindful that it's Mr. Kulu who worked on this matter, not you. My question is, when you make recommendations, negative recommendations, do you not specify what charges they should put? You leave it to the client, be it the SAPS or the EMPD in this case, or for that matter, any other MPS, to decide from your facts that you have analyzed, because you do set out what the allegations are and you give out your analysis in your report. Do you just leave it to them to decide what charges they're going to formulate from your report? And is that the general standard, and is there a reason for that?
I will answer this question like this. We analyze it and give them full details, and according to my understanding on the matter of blue light, because I know that docket also in and out. For instance, the charges that you can draw in that matter, the fraud will be there, misrepresentation, and then there is corruption, that is there. And also, immediately when the vehicle became the asset of the city of Ekurhuleni, if it is taken out of the city of Ekurhuleni, it must be procedural, which means now those assets which were in the register of Ekurhuleni now, it is taken in a bogus way. It also amounts to theft. How did it went back to whatever company, Cat Security? So my take, there is multiple charges there, not only confined to the fraud and...
Yeah. Let me explain, try and explain better what I'm trying to get from you. So your report sets out all of those things. It's clear from your report that
Yes.
There's misrepresentation, there's corruption, unauthorized receipt of donations, and all of that. It's clear from the facts that you set out and from your analysis. But then you make a recommendation. You say disciplinary proceedings should be instituted. That's what you say.
Yes.
My question is, the city can choose, the municipality
Yes.
could choose to charge him with unauthorized use of municipal monies,
Yes.
being that 2,000 rand odd, and that becomes the only charge because you don't prescribe to them, right? Nowhere, in my recollection of that report, nowhere do you prescribe to the city what charges they should bring. You just say you should institute disciplinary proceedings. Now, if the city charges him with only one charge, which is he caused the funds of the city, 2,000 rand, to be used to register these monies, if that's all they do, they would have complied with your instruction to institute disciplinary proceedings. How do you safeguard against that? I don't know if you understand my question.
Yeah, I understand your question now. With municipality, there is a little bit difficult. In the SAPS, there's no difficulty because when we charge a member, for instance, a member committed a murder, when we recommend, we will recommend through criminal charges plus regulation of the SAPS plus standing orders. One offense can carry multiple charges according to the disciplinary of SAPS, even if the member has committed certain. So they will look at all their standing orders. Did he contravene this standing order? Did he contravene this regulation? He committed a crime in terms of common law. So in terms of municipality, it's very, very difficult with their local bargaining council. It doesn't seem to work the same way with the SAPS. I do not know if I have answered you sufficiently.
Okay, maybe let's leave it for now. Let's leave it for now. I'm not sure that you. Maybe you can give a better answer than that. It is what it is as matters stand.
Okay.
Thank you, Commissioner Baloyi. I will try perhaps and engage the witness during break and see if perhaps you could get a better understanding of the question posed to him. And after tea, we can then once again attempt to respond if he can.
Right. Thank you, Mr.
Thank you, Commissioner. Mr. Magagula, I had referred you to your statement at page 8, and we're moving on to the next case. This case you identify as Fontaine CAS 8602/2023. Do you see that?
Yes.
Can you deal with this over the next few pages? And at the conclusion of that at page 11, you then provide the status of the case as we speak.
Yes.
Is that correct? Can you highlight then the details regarding this case before you advise the commissioners as to the status of this case?
Okay. Before I read my statement here regarding Fontaine, I will just state that this case was open because the complainant went to the municipality to complain. So members of EMPD assisted him by taking down his statement. The same statement that was taken by members of EMPD was used to open this case. So from the word go, EMPD was aware of this matter because they are the one who assisted the complainant to open the case. Even though the EMPD statement was not in full details, you will not get the whole story, what was happening there. It must be unpacked so in order for the NPA to prefer the correct charges on this matter. So I'll start by reading. What I will be reading, it will be the second statement that was obtained after I have taken over the matter. On 8 January 2023, between 2200,
You have February here. You just said January.
my apology. On 8 February 2023, between 2200 and 1500, the following day, 2 EMPD members and a white male in civilian clothing reportedly raided a plot at Marigold, Fontaine. I didn't write here. The 2 members we are referring to Adrian McKenzie and Kisha Listol. And the civilian person we are referring to Adrian van der Vaal. They seized stock valued at over 1 million rands, along with the truck and trailer it was loaded with. On the suspect allegedly fled on arrival of the police. This is the summary of the suspect, which is the 3 members I'm talking about. This was their own allegation, this small paragraph.
Mr. Magagula, this white male civilian, was he a reservist or a police informant, or was he just an ordinary citizen?
This civilian is
Adrian
not.
van der Vaal.
Yeah, it's not a reservist. He owns a security company, registered security company, Titan Security, if I'm not mistaken.
Please continue.
I was the investigator in the case. I attached the docket of this matter marked TLM-1. The EMPD stated that the goods were intended for transport to Kinshasa, DRC, where a case was reportedly registered. The seized items were handed to a Congolese national claimed to be the lawful owner as per the Fontaine case 269 of 2023. Through the statement from the complainant, a Malawian national and transport businessman revealed that he was hired by a Zimbabwean national to load and transport a consignment by truck and trailer to Mpumalanga, Akonuku. The consignment was stored on a plot owned by another Zimbabwean national. An argument occurred between the truck owner and the plot owner prior to the arrival of the EMPD members. The complainant, on request, filed an additional statement. He stated that upon arrival, EMPD handcuffed the owner, contradicting their version that suspect had fled. The complainant later arrived and observed his truck being driven away. He contacted a female EMPD officer escorting the truck, during which an argument occurred telephonically. The complainant followed the truck until he was blocked by an accident on Craft Road, Germiston. The complainant checked the Benoni and Eraton SAP pounds and confirmed that the truck was not booked in. He requested tracking of the vehicle, however, the tracker was no longer functional. The invoice of the consignment was obtained and filed in the case docket, together with photographs of the truck after it was booked into the EMPD pound. SAP 299 form for the disposal of seized stolen property to the lawful owner and the passport of the alleged owner of the consignment as per EMPD records. The statement of the owner of the plot, a Zimbabwean national, has not been obtained. The said owner has declined to make a statement, citing fear for his personal safety. His evidence is material and essential to the substantiation of the case against the EMPD members implicated in this matter. I further state that the statement of the owner of the goods has not been obtained, as his whereabouts are presently unknown. Despite reasonable efforts, he has not been located. I further state that, as previously indicated, the EMPD engaged the service of a truck driver to remove the truck from the plot and transport it to the municipal pound. The said truck driver cannot be traced, and his statement has not been secured. As a result, his role and level of involvement in the matter cannot be determined at this stage. There is a prima facie case against EMPD members and the civilian involved. This is evident from the fact that the exhibit contained in the truck were not recorded in the SAP 13 property register. Furthermore, no case was opened by the EMPD members in relation to the impounding of the truck and its trailers.
May I stop you there for the moment? Mr. Magagula. Firstly, I think, please pull out your annexure file, the first file. So I think it should read Magagula annexures 2 of 3, the big file. And I note at your paragraph,
The file is...
the spine should read your name, Tulani Magagula, annexures file 2 of 3.
2 of 3, yes.
Yes, please.
I got it.
If you could have that file and locate TLM1. And annexure TLM1 will start at page 1. Now, before we deal with that paragraph you were at where I stopped you, I think we need to rearrange the file ever so slightly. At paragraph 28, you say this incident occurred on the 8th of February 2023.
Yes.
Correct? You have annexed so far 4 case dockets.
Yes.
In these proceedings.
Yes.
And only this one concerns an event of the 8th of January 2023. The others are on different dates. Is that correct?
That's correct.
Okay. Now, if you go to that same file, to page 272, that is a statement by Brigadier Mkwanezi. Are you there?
Not yet.
272.
It's a page.
Page 272, top right corner.
In red at the
In
top.
red. It's a handwritten statement.
Yes.
Yes. Now, that 272 appears under annexure TLM2. I think it is either misfiled or something went wrong in the copying. Because if one has regard to paragraph 2 thereof, Brigadier Mkwanezi states, I would like to confirm that Officer Kisha Lee Stolz and Officer Adrian McKenzie were on duty on the 8th of February 2023. Do you see that?
Yes.
On the second paragraph.
I see it.
Because the subsequent event, the next case occurs on a different date. So I believe this statement is misfiled under TLM2, and I was suggesting that we take it out and take it to TLM1, because it is in respect of the Fontaine case, at least if the date that Brigadier Mkwanazi reference is anything to go by. Would I be correct?
Well, Mr. If you look at the top of that same page, it has a Hillbrow and different case number. Can you take that into account?
2023.
Yeah, it says Hillbrow, 797, I think, 0323.
Yes, and if you go to TLM2, Commissioner, starting at, let's say, page 93, which is where it starts. As I understand it, that case is /215. It says /03/2022. 2022. So in any event, this document doesn't correlate to the cast numbers allocated to TLM2. We could flag it, we could keep it, but judging by the date, it would have appeared to be misfiled.
Whose handwriting is at the top? The Hillbrow case, the CAS 79703/2023. Whose handwriting is that, if you know it?
The handwriting at the top is my handwriting.
Your handwriting?
Yes.
Perhaps Mr. Lop, you should confer with him.
I think we'll confer, because
Yes,
the
yes.
cast number written there, Hillbrow, is yet a third case, which he's going to deal with. So we will flag it for the moment, and we'll come back and deal with this statement and see what is the correct docket it belongs to, okay?
Yes.
Maybe also when you confer to note in that page 272, the
Yes.
very last line in brackets, it says Stones.
That's yes, that's
Okay.
Hillbrow.
Sorry.
Thank you. Getting back to your statement then, but please don't close that file. You were at your paragraph 38, where you say there's a prima facie case against EMPD members. You had indicated at the start of your testimony that the original complaint against these members was laid by the complainants with the EMPD.
Yes.
Please turn to page 64 of TLM1.
Yes.
And I see that that's on Ikuruleni Metropolitan Police Integrity and Standards form. And the heading of that document is Statement of Complainant/accused/witness. You see that?
Yes.
Then it starts and say I and states a name. Who is that person who has completed this form? The name written there.
It is the complainant, Yusuf Thomas Milos. The statement was taken by Metro Police Officer Owen Mark Prinsley.
And if you go to page 66, that is the end of that document. I see this was actually deposed to and commissioned on the 11th of February 2023. Is that correct?
Yes.
Now, would you like to deal very briefly then with what the complainant at the time disclosed to EMPD regarding this incident?
I will read the statement.
Okay.
That on Wednesday, 8th of February 2023, my truck was loading goods in Fontaine area. Around 2000, I was called that there are police officers there who claims the goods we were loading were stolen. I told my drivers not to move the truck unless to the police station. Brian, who hired the truck, insisted we go to offload the load, but I refused. And further, further use of the truck.
If I may say, it would appear that the photocopy cuts off perhaps the last word on a sentence to the right. So that would read, I refused any further use of the truck.
Yes.
Okay. May continue.
In the morning of Thursday, In the morning of Thursday, 9 February 2023, around 6 a.m., I received a WhatsApp call from an officer of EMPD asking why I'm not allowing her to deliver the goods with my truck. She used cell phone number, I see end there, 082597.
Don't read it out, please.
Oh, okay. I told her to find another truck and not to use mine. She got angry and threatened to pound my truck and link me to the crime. On Thursday afternoon around 3 p.m., the officers chased away my driver from my truck. When my driver reached my office without the truck, and informed me that the officer chased him away and she put her own driver in the truck. I drove there in Fontaine where truck was loaded and found the truck being driven out, and there were 3 Metro police vehicles in front, and behind it I followed them to the N12 freeway where I even took pictures and video. I called the officer asking her where she was taking my truck to, but didn't answer. Instead, she
blocked my number.
Blocked my number, yes. I followed them until the interchange of N12, R21, and N3, where I was blocked by accident, and they proceeded. I lost them there and couldn't see them again. I then went to Fontaine police to report theft of truck, where I was told they can't open the case as they saw the truck moving with police escort. As they didn't think it's stolen. On Friday morning, I was informed by Brian that officer took my truck to Boxback EMPD Pound. I went there to see my truck and found it with stolen parts and diesel 920 liter drained, auto shift and ECU also stolen.
And this you say is the statement of the complainant?
Yes.
If you go further on page 67, there is another statement.
My
apologies.
Please repeat everything you said.
I was going to say, so you say that was the statement of the complainant as it was given to EMPD?
Yes.
On 11 February 2023?
Yes.
If you go further on, then at 67 is another statement. You don't have to call out the name. Just the person listed there is identified as a truck driver.
Yes.
And then you can deal with the contents of that statement. Thank you.
Okay. This is the truck driver hired by the complainant. This is the lawful driver. I'll read his statement.
Thank you.
I was at work on Thursday early morning when a police officer and I beg your pardon. I was at work on Thursday early morning when a police officer and my workmates came to my truck and informed me that I need to off-hook my trailer and go help one that was stuck. I off-hooked my trailer and went to help the off-hook truck. I then hooked the trailer that were loaded there in Fontaine. The officers instructed me to drive the truck and follow them to an unknown location, but my boss, owner of the truck, told me not to drive anywhere but to police only. We stood there all day until around 3 p.m. when the officer chased me out of the truck. I then went to our company and reported to my boss that the police chased me out of the truck. That is all I can say.
And if we go further, then at page 69, I see that, well, the deponent signs, it appears to also be dated 11th February 2023, and it's commissioned at the bottom on the 11th February 2023. You see that?
Yes.
Now, if to go back to page 57, in fact, we started 55. Are these the documents pertaining to the truck in question?
Yes.
Now, I'd like to move forward to page 59. Page 59 to page 63 are pictures in your docket.
Yes.
Are these the pictures? What pictures are these? There are 5.
In page 59 is the picture of the load that was loaded in the truck in a form of boxes.
And the next page?
And 60 is a picture of the truck and its trailer with registration shown.
And now at page 61?
It shows the trailer.
And also at 62?
Is the trailer.
And 63?
A trailer and a little bit of the horse.
Okay, now where do these pictures come from?
These pictures were taken whilst the truck was at the pound of EMPD by the victim, the complainant.
Did they form part of the docket at the time the complaint was laid?
No, it didn't form the part.
They were provided to you?
Yes.
With the document then I originally referred you to, the complaint to EMPD at page 64 and the second report at page 67, what do you suggest the EMPD could have done about this matter? What is contained in those documents and what would it have enabled EMPD to do?
The EMPD should have opened a disciplinary hearing against the members because they had the information at that time. Furthermore, to get more evidence, the important part, it is the pound itself. The pound plays an important role because it's where we found who booked the truck in. What was the reason for booking the truck in the pound? Is there any case number for the truck to be booked in? And EMPD is in better position. They know when a car must be pounded. one or two mistake in a vehicle doesn't warrant the car to be found. For instance, the car, when you look at the inner teeth, it says this car is white, and here they are seeing black car. Maybe during the registration, because the car now has been owned by many people, there might be somewhere where something went wrong. So it doesn't warrant for the car to be booked in, to be taken out of the road. So you need to follow up and do further and give a traffic fine if it warrants a traffic fine. So the EMPD was in better position to go to that pound to see what was the reason for this truck to be pounded here. So, and when you look here, the procedure, those EMPD members didn't follow the procedure because they didn't book the truck in the pound. They dumped the truck in the pound. Somebody has to note the truck that, okay, this truck entered the pound on this time and the people were in hurry, they ran away. So that will have given EMPD something to work on. And it is not a criminal offense for them dumping the truck there. But the misconduct is there. They know the procedure, how to do things according to their standing orders and rules.
And when you took over, when you started investigating the matter as IPID, were you able to obtain statements from the implicated officers, EMPD officers?
Yes.
I have in annexure TLM 1 from page 9. Statements obtained during the interview of the what are called suspects.
Yes.
And the first one starts at page 13. And that would appear to be a statement, according to page 13, line 1, of Kisha Lee Stalls, a white female employed by EMPD as a constable. And the second paragraph then states, on 8th February 2023, at that time, at 2300 hours, she was contacted by a confidential informant regarding a suspected stolen load in Fontaine on a plot. Then she sets out her version of what transpired.
Yes.
The next statement is at page 24. And that now is the statement of Adrian Norman McKenzie. And he states, I, Adrian Norman McKenzie, employed by Ekurhuleni as a Metro Police officer, gave statement. At paragraph 2, he then states, on 8th February 2023 at about 23 hours, I was contacted by Kay Stalls, who informed me that she had received information about a suspected stolen load that was in Fontaine, and that she had informed our supervisor. Also that we must proceed to Fontaine, you see that?
Yes.
So, these you obtained on the 2nd of May of 2023, as reflected at page 18.
Yes.
Is it your case that the EMPD had the necessary information to start investigations, internal investigations, and they would have obtained the very statements that you 3 months later, obtained from Mr. McKenzie and Ms. Stalls, who confirmed that they are the police officers involved? And then based on the facts of the case, EMPD would take a decision whether or not to institute disciplinary proceedings. Is that your case?
Yes, it's my case. And to add more there, we have a good relationship with EMPD. When a case is open against any member of EMPD, they knock at our door to ask for more information. and we gladly give them those copies, even if it is in an initial stage, and when the case progresses, they need more information, they come to us. The person who usually communicate with us, who is sent, is Binel Musepe, who comes to the office most of the time. So our communication line is open to them at any given time.
Just so that we are clear, the complainant made a statement to EMPD.
Yes.
So how did this case end up with IPID?
Because it was now a case at Fontaine police station.
And then EMPD referred it to IPID.
The police, the Fontaine referred it to us now.
Oh, okay.
And who reported it to Fontaine SAPS? Is it EMPD or is it the complainant?
It will be EMPD because the SAPS in the first place refused to open the case for the complainant for the fact that they saw the truck being escorted by members of EMPD. So they didn't believe that the truck has been stolen because they said we saw the truck being escorted by Metro Police. So now EMPD is coming back with statement now to say, can you assist in opening the case? Now because it's law enforcement, now the case has to be cast now.
Okay. Maybe then explain how it works, because what we've seen with the blue lights case is that EMPD laid a complaint with the SAPS. And as I've understood the evidence, then from the SAPS it came to IPID, this case. From the SAPS they informed, IPID became involved. You did, and then an investigation was done into that matter, which resulted in a report and a negative recommendation to institute disciplinary proceedings. Why is this Fontaine case treated differently by IPID? Because a complaint, as you tell us, a complaint was laid with Fontaine SAPS by EMPD. Why does IPID not then do the same as you did with the blue lights, where you do your investigation and then you provide a report to EMPD on the basis of which they then institute disciplinary proceedings?
Let me clarify the blue light. The complainant, which was EMPD, came to IPID and they didn't went to the police straight to complain. EMPD came to IPID to complain about the issue of blue light, and we informed them that we need statement. We cannot open a case without a statement. And then they provided such statement, and then the complainant himself, Commissioner Spies, signed the statement and 3MA and 3MP, and then I took those documentation to the police station to open the case myself on behalf of him, because every document was there. So in the matter of Fontaine, the complainant himself was not assisted by the SAPS. He did go as usual, as a normal complainant, to go and open a case at a police station. But for reason known by the police that we saw the truck moving with EMPD, we do not think the truck was stolen. So we are refusing. So the complainant was not satisfied with that because he wanted this issue to be registered. He went to EMPD. So EMPD took down his statement with their powers. They went back to the police station to clarify that this statement, this docket must be open, as previously not accepted by the police.
Yeah, what I'm trying to understand is at which point, so you because you say that EMPD had sufficient information, they could have instituted disciplinary proceedings.
Yeah.
I'm not quarreling with that. What I'm trying to understand is, does this mean, therefore, because the case was reported to EMPD and EMPD has the necessary information, does it mean IPID itself, when it becomes aware of this case, however you became aware of it, you don't do the investigation which ends up in recommendations to the city? That's what I'm trying to understand, how the process works.
Yeah, now I understand the question clearly. It will go the same way as Blue Light. After the completion of the investigation, we will do recommendation to EMPD, because the case cannot be finalized without the recommendation both to the department and the DPP. So it will go the same way. So currently the investigation is not yet finalized. That is why the report is not yet out.
Thank you. Thank you, Mr. Magagula.
Thank you, Commissioner Baloyi. Mr. Magagula, that then takes us to paragraph 39 of your statement at page 10. Are you there?
Yes, I'm there.
Please deal with paragraph 39.
In addition, the property was released to an individual who claimed to be the lawful owner by means of the SAPS 299 official register, which is not an authorized document for use by EMPD members.
Can I ask you to stop there and go back to your annexure bundle, page 13? And I am looking at the statement of Ms. Kisha Lee Stalls, page 13, 13.
Yes, I'm there.
I see at the bottom of page 13, Ms. Stalls notes the following, and I quote, "The stolen load with Kinshasa case was returned to the owner on a SAP 299. I'll stop there. Do you see that?
Yes, sir.
And that is what you are referring to at your paragraph 39.
Yes.
Can you talk us through what an SAPS 299 is, this official register, and whether anyone investigating the whereabouts of the goods would have, I take it would have regard to that document at the pound, and that would, whether that would inform them as to who booked the load in and who checked it out to hand over to the supposed owner. Can you, are you able to explain to us what one learns from SAPS 299 document?
SAPS 299 is a South African police register which of stolen return of suspected stolen property to the owner. It is used by SAPS. It is not used by EMPD. And to release property to a lawful owner also, the property cannot be released by any member. It must be an officer. So what does SAPS 299 tell us is that, for instance, something is stolen at Edgar's, shoplifted at Edgar's, and Edgar's needs that property immediately. Then a police officer, after Edgar's must satisfy the police officer that this is my property, producing proof that this belongs to me. And then SAPS will make a copy of the lawful owner from Edgar's ID and the receipt of that item, that, because when you say that belonged to me, here is the receipt of my property, and then SAPS will make all those documentation and attach, and you sign that register and they release that property. So here what I see, Kisha Listol was make copies of this documentation and keep it to herself in the car and release when they found something in the street or they want to take one property to another to legalize the property, and then they sign that SAPS register and give it to someone. Here in this matter, it's fine. There is a...
Are you assuming that this is so, or do you have facts to back up what you say? That is, that Officer Stolz made copies and would then use those copies whenever she saw it necessary.
Yeah, there is in the docket, there is a copy of SAP 299,
All right.
which she signed.
We'll try and
Will take
locate it for
us-
you. Yes.
Oh, thank you. Thank you.
As you explain, we'll try and locate that. Thank you.
Please continue with your explanation.
Even SAPS members, in terms of this SAP 299, in the patrol vans, they don't keep those forms to themselves as SAPS members. So in this matter of Kisha Listolz, it can be seen that they are keeping these copies for their own reason, which is not lawful. It's unlawful to have that form. Because even in the SAPS, when the officer releases it, it must still be noted in the occurrence book. It doesn't result in filling up the 299 and it ends up there. It must be in the occurrence book so that after 2 months or 1 year, a person comes and complains, we still have the register to say OB entry of that release of property is here.
To your knowledge, does the EMPD have an equivalent of the OB, the occurrence book?
Some of the units have, but it's not up to the standard of SAPS. The standard of SAPS, the occurrence book, when it finishes, they archive it. Another new book. So from previous year, if you want a certain month, they will just go to the year and month and pick up that book and look for that specific entry. So for EMPD, it's some of the units, they have it. It is not, I cannot call it officially, because if I can go to them that I need an OB of your success or your duty on, duty off for year 2025, I might not get it.
Thank you, Mr. Magagula. I was quickly flipping through Annexure TLM1. My challenge is I don't know what an SAP 299 looks like. And for the moment, I cannot find a document that, but as I understand, this is the complete docket. During T, we will try and locate SAP 299. We were still at your paragraph 39 when I stopped you, line 3, where the second sentence starts now. Are you with me? Your statement, page 10.
Yes.
Paragraph 39.
Yes.
You had read the first sentence when I stopped you and I asked you to deal with SAP 299 official register, you remember?
Yes.
So we are now at your second sentence at line 3. If you can take it from there.
The investigation has not been finalized.
It's don't you say that there was also no specified?
No, there was also, yes.
There was also no specified location at which the alleged lawful owner received the consignment, in bracket goods. The investigation has not been finalized, and accordingly, recommendation to the EMPD and referral of the matter to the DPP have not been compiled. Such recommendation and referrals remain pending the obtaining of statement from key witnesses identified above.
Would you say the investigation has stagnated at this stage? That's my sense when I go through what you narrate about this specific case. Would you say the investigation has stagnated, or would you say you still have leads? I don't want you to tell us what those leads are if you do have them, but it seems to me the investigation has stagnated. Some people have disappeared, people that you would have loved to take statements from, and one that is available and whose statement you would like to obtain is refusing to give you that statement. So it's on that basis that I'm asking you, would you say the investigation has stagnated?
I will agree with you, but I hope to persuade this witness, which I believe at a later stage you will comply. Currently, he is afraid. I don't want to lie. To communicate with him, I communicate with him. He says he's afraid of the police. The question will be, hey, Magagula, you know the police, they will kill me. Then I don't want to be in that position. So I'm trying to show him that there is witness protection, all those type of resources that the state have that they can provide him with to be safe. So currently it is stagnated. It is not moving.
Besides offering witness protection, are there any other means of obtaining a statement from a recalcitrant would-be witness?
I do have a plan which, if I can reveal it, everyone is listening, the police officers will be knowing how Magagula is going to handle this matter. And then
my focus, and by no means imputing impropriety on you, but my question was about lawful means. So are you saying you do have lawful means?
Yeah, it is a lawful, lawful one, 100%, where the witness will be comfortable. And they won't be forced, it will be voluntary.
Okay. Thank you, Mr. Magagula.
Thank you, Chair. Commissioner.
Ms. Magagula, my concern is this case is from February 2023 and it's now February 2026. I don't know, maybe I see it differently. The statements you have from the owner and the truck driver and the two statements from the EMPD officers and the failure to use proper documents to release the property. And you say the manner in which it was impounded was also improper, how it was not recorded in the SAPS 13. Are those facts not sufficient to make recommendations of a disciplinary nature? Because I'm concerned that if you do manage to persuade this other witness to give you a statement, and it's now 2018, 5 years after the event happened, 26. It will be difficult to, prosecute people because memory fades, documents go missing, people pass on in the process, the police officers retire in the process. In fact, in the case of Stalls, we are told that at the end of January 2025, she retired from EMPD. So do you not take those things into consideration, and do you not say, I know my investigation is not 100% complete, but I'm satisfied that with the 75% that I have, disciplinary proceedings can be instituted? Do you not look at it that way?
In terms of the, let me start with the DPP. The best way, as things stand, we have a prima facie case where I can start with the Director of Public Prosecution, making an inroad in the Director of Public Prosecution to find which charges I can prefer, because these members here, if you look at them, they want to run away. The manner, the modus operandi, because the case was registered as theft of the truck. Now, the truck, when you look at the transaction, it is not stolen, because at the end of the day, they have returned the truck to EMPD. So they wanted to kill that charge of a truck. They were very, very clever on that, but it's not cleverness. Now, they have a second problem. The truck was moving in good condition, and it was intended to go to Mpumalanga, Akonok, which is about 500 kilometers from Port Fontaine. So it shows that the truck was in working condition. 3 days after the owner received the message that the truck is in EMPD pound, there is another charge now, which is then theft out of motor vehicle. Some parts of the truck on its own, some parts were stolen. The owner has to go and buy parts of the truck to put it in order for the truck to be able to be drivable again.
Even diesel, as I read this.
There is a
900
part,
liters.
diesel also, but there are parts of the truck. There are parts of the truck that were stolen there. So it's theft out of motor vehicle, not theft of the truck, because that one they tried to make a U-turn, because theft, it will be to deprive the lawful owner of his property permanently. So here they can come and say, we didn't want to deprive him permanently. We booked the truck in the pound. So in terms of that, I'll look at that area of that charge of theft out of motor vehicle. We have another challenge. I have another challenge in terms of the charges. Their aim, the intention of the officers was not about the truck. It was about the property that was inside the truck. The property worth more than 1 million rand. That property that was stolen there, it was not recovered. They allege that they gave the lawful owner somewhere. The importance of the witness which hired the truck owner to transport these goods. That statement is very, very important in that aspect.
And, I'll take you back to your answer, I think, to my last question. How soon do you intend to use the means that you referred to? You said you do have other lawful means to obtain the outstanding statement. By when will you do that?
In the next 4 weeks.
Why that long?
I will be revealing that strategy.
Oh, okay.
Mr. Magagula, this is a follow-up on Commissioner Kumalo, but slightly different. You have listed certain shortcomings. For example, the use of the SAP 299 document. You say they should not have, it's a wrong document to have used, but also it should not be in their possession because it's not an EMPD document.
Yes.
That's one. Just keep note of this list. You've got that. And then there is the release of the goods according to stalls. The goods were released to an owner, but there's no record of who that person is. It just says the owner. You say that there was no case opened for impounding the truck and trailer. You also say there was no location, no specified location where the goods were released. And then I want to add to that list that there is no record, a record of the goods being released. We've got a statement saying the goods being impounded and then released, which I expect would happen if the police come into possession of any matter. They would record it properly. This is what they received, and then this is what they released and who they released it to. But that list of things that were not done and which you record in your statement seem to me not to, for them to be provable or to constitute charges for disciplinary purposes and to be proved as misconduct does not depend on a complainant statement. It's a matter that you have on record, and employees could be charged on that without even having a complainant present.
Yes.
A complainant as in the owner of the truck and the owner of the goods. Having said that, it seems to me then that the IPID should be able, or should have been able, and should still be able to make a recommendation to the EMPD to discipline on just these issues. Why has that not happened? Why have you not drawn conclusions on these lines that there's been an infraction of this and that and that and that shortcomings on Stolz's own statement? Here are the shortcomings or matters that are disciplinable, and we make a negative recommendation that she and McKenzie be disciplined. Why has that not happened? And why can that not happen?
This question, the SC has canvassed it. We spoke about it a lot of times. The standard operating procedure of IPID doesn't allow us to make a recommendation without the completion of the case. So when we make recommendation, is when the investigating officer says that everything is here in the docket, and you compile your report to DPP and the stakeholder, which will be EMPD or SAPS. So we do these reports when we finalize the matter. Because the system, you must feed this recommendation to IPID system, electronic system. And it is signed by the provincial head that you have finalized the matter. So even when the auditors comes, they will say, in this matter, everything was done, and it was done on this date. So when you see our PDMs, after we have done our memorandum to DPP and SAPS, DPP might not be satisfied. The office was convinced that the matter is completed, but the DPP can say, no, Magagula, you have not yet finalized the matter. Go and do 1, 2, 3, 4. But already on our system, it will be finalized because were convinced that everything was done. So I do not know if I answer your question. The predicament, even now when I live here, is because I can do the recommendation, but will my boss sign it because the standard operating procedure says that you must do recommendation when the matter is finalized?
I've not seen the prescript that you are referring to, but depending on the language, as presently advised, I feel that IPID is unduly constraining itself in this sense. If this is about the completion of investigations, I do not understand why you should tie EMPD investigations to investigations intended for the criminal process. If, on what you have done, you are of the view that enough is now in existence for purposes of pursuing a disciplinary process, why can't you say investigations are now complete insofar as the disciplinary process is concerned? And then you are able to fill in that electronic document and you are able to convince your superior to sign off on that. Are you perhaps not unduly constraining yourselves? Are you perhaps not interpreting the prescript you are referring to wrongly?
Yeah, I agree with you, Commissioner, that as soon as we establish that there is a prima facie case, we should
that is exactly my point.
Yeah.
Practically, you may easily establish that there is a prima facie case for purposes of the disciplinary process.
Yes.
Which means that with regard to that process, the investigation is complete. So why can't you close that off, seek your superior's signature, and fill in that form? And where it says, is the investigation complete? You say yes. Why can't you do that? Sitting here now, I don't understand why not, unless you explain it.
And maybe to add to that if it's quite conceivable that you may, I know you have just said to us that you have means of getting these witnesses, additional witnesses that have disappeared, but it's conceivable that you never ever find them. And the way you describe your standard operating procedure and your reasons for not having recommended yet disciplinary action to the EMPD, that could be the end of this case, because you never get those witnesses. And so you have officers where there's a prima facie case against them, which gets proven on a balance of probabilities, and in respect of whom your witness statements are irrelevant, right, for reasons that I've earlier discussed with you, but they actually walk scot-free because your standard operating procedure says until you've bedded everything together and you have a docket that goes to that's approved by the DPP, you may not recommend to the EMPD to institute disciplinary proceedings. Something is seriously wrong if that is what your standard operating procedure says or requires of you.
I agree.
But bear in mind that I say you may well be misreading that standard operating procedure. So do you want to comment on all this? I'm sure you still remember everything I said, and you remember what my co-commissioner, Commissioner Baloyi, has just said. Do you wish to comment on all that, please?
In terms of me maybe not understanding the standard operating procedure, I'll be saying it means that most of the caseworkers of IPID, if the point is that we are not understanding that standard operating procedure, including our boss who must sign the said recommendation, because it will be written, definitely so.
Yeah. You see, the simple point is this: what may have to be proved for purposes of the criminal case may not necessarily be the same as what needs to be proved in respect of the disciplinary process. So it just doesn't make sense that the two should be bound up together, such that you cannot move on this one, even though everything that needs to be satisfied has been satisfied. It just doesn't make sense to bind them together like that. Do you get what I mean?
I get it.
Do you agree that you may possibly be misreading the standard operating procedure? I'm suggesting this to you, not having read the procedure, but you accept that you may well, because otherwise,
I accept.
Otherwise, whoever framed it would have framed it very stupidly.
Yeah, I accept.
Thank you.
And do you accept, sorry, Ms.
Yes, ma'am.
Do you accept that if you have read it correctly, if what you're telling us is in fact what it is, then it's a major flaw in that standard operating procedures and it has to be reconsidered?
Yes.
So that it permits you to do what the chair is suggesting should be the way things are done.
Yes, I agree.
And
it will be fruitful.
Yeah. And we are not blaming you. We are not blaming, as we understand it, you are suggesting that this is how all of you operate. Yeah. Ms. Sidlo, perhaps we should throw this one back at you for you to please follow up on the actual content and true reading of this procedure.
In fact, we've made a note. These are some of the documents when Mr. Kiafela Kai returns for the IPID stream. This would form part of his bundle.
Yes.
To talk generally about IPID and the SOPs and any other regulatory instruments they have. However, although I'm hesitant to tell the commissioners this, we have tracked it down. It's an SOP dated 25th March 2019, but I won't put it to the witness. The witness hasn't been confronted with this document. It would be grossly unfair, but we will pick up the issue. And I suggest so, confident that it need not detain us regard being heard to the peculiarities of this particular case. Yes, it's still a live issue that must be answered in regard to the others. So if I may just deal with the witness, confining ourselves to this case, to address the very concern that the commissioners raise, that why could disciplinary processes not be initiated within EMPD regarding this Fontaine matter, and to determine whether failure to do so was caused by the delays on the part of IPID. The reading of the statement doesn't fully answer that question, but the reading of the docket, I think to a large extent does. So perhaps if I take the witness through those documents.
Yes, Ms. Sidlo.
Thank you. Before we do so, Chair, my very able attorney has assisted with SAP 299 or 229. I don't know whether it's experience in being arrested or in arresting or solving criminal cases, but that is to be found in TLM1 at page 33. Mr. Magagula, if you go back to your annexures file, remember the annexure file we're working through looking at your docket in this Fontaine matter? Please go to page 33. Are you there?
Yeah.
I'm advised, and I see at the top right corner, unfortunately the page number is imprinted over, that it reads SAPS 299. Is that that SAP register we spoke about earlier?
Yes, it's the register that I spoke about.
Okay, the chair had asked us to locate it, so it is located. So I don't know if the chair would like to consider some questions on this SAP 299 that Ms. Kisha Stolz references in her statement to say the goods were returned to the lawful owner.
Not
In
at
terms
this
of-
stage.
not at
I'll
this
see if I
stage.
can.
Then just
apply
to
my
note it
mind
for the
to-
record.
Thank you.
Then, Mr. Magagula, in order then to deal with the issue that the commissioners engaged you on